We all set now?
We are.
All right, perfect.
How are you?
Good. All right, so we'll call the meeting to order. Gonna have everybody introduce themselves.
Judy Carl.
Deborah Burrows.
Scott Corey.
Nick Vecto.
All right, and everybody, did you guys sign in the audience sheet? All right, perfect, thank you. So we're gonna be here today to look at the appeal request for James and Jean Baxter, reference to tax map 45, lot 1326, known as Zero Beechwood Circle. I don't think it has an address yet, in North Waterboro. We do have jurisdiction. We did receive everything on time, I'm assuming. I just saw some stuff today that I hadn't seen before, but obviously we have it. And so with that, we'll let you guys get started.
Okay, great. Well, good evening, everyone. I'm Joe Sabisky. I'm with Perkins Thompson up in Portland. I'm here on behalf of Jim and Jean Baxter. They applied for a variance in order to build a... Good? Good, thank you. All right, thanks. So Joe Savitsky, I'm here on behalf of the Baxters. We have a revised application for a variance. I believe the board's familiar with the initial application. That was for a 24 by 50 foot residence. And the board found that that application was met the ordinance standards with respect to 3 of the 4 factors for a variance, but not the 4th, which is that the property can't yield a reasonable return unless the variance is granted. So went back to the drawing board and came up with a smaller footprint for the proposed house, 24 by 40 instead of 24 by 50. That allowed us to reposition the house somewhat, to take it out of the front setback altogether. So the initial application requested a variance of that setback requirement in addition to the shoreline setback. But with the smaller footprint, house is not quite as long. We pulled it back slightly from the shoreline. I believe it's 81 feet from the shore as it's depicted on that plan here, and entirely outside of the front setback. And that was as far as we could get away from the shore and out of the front setback, considering the need for the setback, the septic field, which has its own setback requirements. So that limited us even further as to where the position of the house could go. So this is, I think, as far enough away from the resource that we could possibly get it. It's got to be a 1-story building. Mr. Baxter's limited in his mobility, so he's got to be living on a single-story house. So smaller footprint really isn't feasible. So that's the revised application. And what I'd like to do now is just go through the standards. So if you'll put up with me for a little while longer, I'll try to be brief, although I am a lawyer. So as the board is well aware, there's 4 standards that you need to meet in order to get an undue hardship variance. And the board found that 3 of those criteria were met with the initial application. Those were: the need for a variance is due to the unique circumstances of the property and not to the general conditions in the neighborhood, that the granting of a variance will not alter the essential character of the locality, and that the hardship is not the result of action taken by the applicant or a prior owner. So the board came up with a reasoned decision on the initial application. I'm assuming that you folks will feel similarly about this application with respect to those 3 standards anyway, so I'd be happy to answer any questions about those 3 standards, but what I'd like to do, if it's all right with the board, is just move on to the 4th standard, which was sort of the sticking point with the initial application. That's that the land in question cannot yield a reasonable return unless a variance is granted. So there's some case law on this, and in the case of a shorefront lot in particular, there's some cases in which a variance was not granted even when the lot owner couldn't build a single-family dwelling. But as I pointed out in a letter, I hope that you received as part of our application, these circumstances are distinguishable from those cases. There was one in which it's called the Toomey case, Toomey versus Town of Fry Island. There, the property owner had another inland lot located within walking distance of his shorefront lot. And even though he couldn't build a house on his shorefront lot, the court said, well, you got another lot within walking distance. You can still use the property for other purposes. So you didn't meet that last standard, cannot yield a reasonable return. Another case, the Hall case, said even though you can't build a house, you can drive your RV, trailer, tent, whatever, hook it up to power and use the property that way, and that was considered a reasonable return. But neither of those are possible here in the Baxter's case because of a restrictive covenant that's been placed on their lot, and I believe all lots in the subdivision in which the property is located. And I quoted that in the letter, but I'll read it again here. It says that the property is subject to this restrictive covenant, among others. The land conveyed hereby shall be used only for single-family residential purposes. No trailers or mobile homes shall be placed or maintained on said land, and no tents shall be placed or maintained thereon, except that tenting by children only shall be permitted after a dwelling has been constructed on the land in compliance with the provisions of this deed. No trade, business, or commercial activity of any nature shall be conducted on said land, the Baxter's property. So that's a pretty broad restrictive covenant, and also pretty unambiguous as to what it restricts the use of the property to. And there's case law on this as well, and I don't get into this in my letter, so I'd like to sort of walk you through it here. There's a few cases that examine that language, restrictive covenants that limit the use of a property to single-family residential purposes. So one of them, it's San Severino versus Greger, 2011. And this was a case up on a lake in lakefront property in northern Maine, where I happen to be going next week. There, the court found there was a property owner, there's a restrictive covenant on the land in question there, very similar to the restrictive covenant that impacts the Baxter's property. It says, the lot shall be used only for single-family residential purposes, and no commercial or business activity shall be conducted on the lot. So there, the property owners were cutting down trees and selling them, and that was pretty clearly commercial or business activity. But what they did say is that setting aside the proposed use, the language, single-family residential purposes, is pretty unambiguous, and it means exactly what it says, only for single-family residential purposes. So, another case, this is ALC Development Corp. Versus Walker. And Ben's firm, as well as mine, apparently was involved in this case. That was before our time, Ben, it was back in 2002. Examined a similar restrictive covenant, which provided no lot shall be improved or used except for single-family residential purposes. Very similar to the restrictive covenant that affects the Baxter's property. And there, all the property owner was seeking to do was build a road to access other residential properties. And the court said, no, does not comply with the restrictive covenant. That says use of the property is limited to single-family residential purposes. It's pretty unambiguous. That's what the property use is limited to. So when you read those two cases together, it's pretty clear that given the restrictive covenant on the Baxter's property, what they can use their property for, and it's for single-family use. They can't even put a tent there. It says expressly that they cannot do that unless they've already built a house there. They can't drive their RV there and park it there because that's prohibited also. No trailers or mobile homes shall be placed or maintained on said land. And no commercial activity of any kind is permitted on their land. So in the board's decision on the initial application, quoted this Marchi versus Town of Scarborough case, in which there's some language in that case that says, here the record reveals that the property is strictly confined to residential use, is unbuildable unless the variance is granted and the applicant is not an abutting owner. So that wasn't a shorefront lot, but what it did say was, if you can demonstrate that the use of the property is limited to only single-family residential use, then you can't get a reasonable return unless a variance is granted allowing you to build a single-family dwelling on that property. So in light of this authority, I'm hoping that the board will give some thought to the revised application that the Baxters have submitted, and find that they really can't do anything with the property other than build a single-family dwelling on it, which is exactly what they're seeking to do. And with that, I'd be happy to take any questions.
Okay, probably a question for you, either one you can answer, but what is the property currently being used for? Is there any use at all? Like, are you guys using it during, like, walk in, walk out kind of deal, or?
Yeah, we have a dock on it.
You have a dog there? Okay, all right. Okay. You guys have questions for?
That was my question.
Go ahead.
No, that was.
No, she.
Oh,
Oh, well, so you can have picnics there, and you can have a dock, and a boat, and that is,
Until the association says, no, you can't.
So,
why would the association say, no, you can't?
is there a law change, either be something about some of these covenants not being legal or something like that? I heard in the paper a little the other day that there was certain neighborhood associations and things were no longer allowed to tell you what you could and couldn't build on your property. Is that, either one of you know? It was in the paper, I don't remember the case, but, okay.
Not familiar with that.
All right, thanks.
Specific case. I think to address your question, there's really only one case, that's the Toomey case that I mentioned, where the law court said, even though you can't build a house on the lot, you can use it for recreational purposes, but there was no restrictive covenant on that property, at least in the evidence before the court. And that owner of that property lived within walking distance of that. He owned another lot in the same subdivision. He could walk there from his property. It's pretty easy to get there. That's not the case with the Baxters.
Do those restrictive covenants, I didn't see anything in there that said you couldn't have a picnic or use your boat or...
Yeah, what it does say is that the use of the property is limited to single-family residential purposes.
Yeah,
So-
but it doesn't say you can't go there and have a picnic and use your boat. I mean, use your boat, don't you? And it has a dock there. Nobody stopped you from doing that, have they?
Sorry?
Nobody stopped you from having your dock and your boat there, have they?
No.
Were you under the impression when you bought this property that it was buildable?
We were under the impression that it was the term was, again, I can't remember exactly what the Realtor said for the term, but basically, it's not a grandfathered in-lot, but it's part of the subdivision original, so it is a buildable lot, but you have to seek a variance because of the Shoreline Zoning Act that changed it.
So it's a grandfathered non-conforming.
Non-conforming lot.
Okay, yeah, I
Which,
Yes.
Yeah.
yeah,
So it's a non-conforming lot of record. It was established in the subdivision in 1971 or 73 or something like that. And it doesn't meet the lot area requirements of today's ordinance, but it did at the time that the subdivision was created.
There
Where
was
is this
no
case law?
zoning at the time.
oh, sorry, go ahead.
There was no zoning in 1971.
Correct.
The zonings took place in 77.
Correct, and so there are typically, there can be two separate sets of issues when you are constructing, a house on a lot like this. The first is generally that the lots in older subdivisions like this are undersized, so they don't meet minimum lot size. This one does not, but because of the date that it was created, it is a buildable lot, meaning that it does not need to meet the minimum lot size imposed by shoreline zoning in order to have something, a structure of some kind built on it. The question before the board tonight, though, is simply of whether or not a variance is going to be granted from the required 100-foot setback from the water. So that's the only question that's before the board.
Did any of the cases that you brought up, I know a lot of them were not shoreland, but was there any that gave that variance? Which one of those cases was the shoreland case? Because I knew there was one, but
Yes.
I know Toomey was one, obviously.
Toomey
there's
was
shoreland.
was a short.
We hear about that one a lot.
Yeah, I bet. Right. So Toomey and I think the Hall case as well. The Hall case was where they said, the court said you could hook an RV or trailer up.
Right,
And that
and that's
was
obviously
reasonable.
not
Turns out
allowed.
they can't do that. So
Right.
that one's clearly
Yeah.
different. And what I'm arguing to the board tonight is that Toomey's also different because there were no restrictive covenants, and the owner of the property lived within walking distance
Right.
of the lot. So they're both distinguishable
Yep.
on those. Toomey's also 17 years old, and 6 of the 7 justices that were on the law court are no longer on the court, so for what it's worth. But, I didn't finish answering your question.
Sorry.
The other cases weren't, they weren't variance cases. They were cases that were exploring restrictive covenants, specifically restrictive covenants that,
Well, I mean,
that had
I think we agree that
single-family
the restrictive
residential
covenants,
purposes.
he's gonna put a single-family home, he's not, it's not an issue, to me, and personally anyway, and I don't know, not to speak for everybody, but we're here for the setback, right? I mean, that's essentially what we're here for, so. You guys have any more questions? But does anybody in the audience have anything that they would like to share with us today?
Yeah.
Did you guys go first, or is it the audience first?
Audience first.
Audience first, that's what I thought, that's what I had the right order, so I just wanted to make sure.
Side, I'm just gonna get it.
All right, yeah, whoever,
Yeah,
yeah.
hi, 34 Beechwood, Canaan, Reverend.
Can you just come, because I don't know if the mic, is the mic gonna pick her up?
Yeah, I think.
Where do you want me?
Right up at the
Yeah, if you could just come up to the podium, just because I don't know if the microphone's gonna pick you up for all those, people watching at home here.
Oh, I keep forgetting when people are at home, I couldn't.
I'm sure that they're stacked up.
Yeah, hi, my name is Joanne Canane, C-A-N-A-N-E, lot 13, 23, 24, 25, we abut the 26. We've owned the lot since, we've owned the land since 1980, let me see, 82. And when we decided to build, it was the 100-foot setback. So we did build the house in Saco River was pretty adamant. They sent people out, they measured before and after the property got put on. My concern is the 100-foot setback. Our land gets a lot of physical abuse with the boats. I don't see the lot anymore ending where it's supposed to end. Everything's... So my question is, when the Baxters started building, you have pictures in there and stuff that I submitted for the last time?
The last time.
Oh, okay.
And
Yep.
they, my opinion, and I'm not, I'm just taking it as an abutter. The land got pretty much wrecked. They had a front loader, I don't even know what you call that machine, at the shoreline, in the water,
Who's this? Okay.
the Baxters. I mean, you can see it in the pictures I sent. I mean, they're just, the land is like, so I don't understand how, I don't know why exactly we're here to authorize another thought of a new variance for what, a home that's 10 feet smaller than the last one? Where is the 10 feet? Is it this way? I'm not good at reading the maps.
It was lengthwise, so if you look at the red.
Oh, I didn't even see
Yeah,
that,
the red
so-
box right there, it would have been 10 feet further towards your 25 property. It would have continued essentially.
It would have, but now it's not. Now it's closer to the 1326.
No, well, no, I would say that we'll call it the bottom side, for lack of a better way to put it. The side closest to 1327 is pretty much the same place it was, it's just 10 feet shorter on the other end. Is that fair representation?
On
So
the,
it's-
towards 1326?
Yeah, so it's 10 feet less towards, it was 1325, it had 10 more feet going that way, and now it's got 10 feet less.
Okay. Here's my concern. His house, I have a lot of concerns, but when you purchase a property such as that, I mean, you don't have the pictures? When you purchase a property such as that, you are told it's buildable or it isn't buildable.
Oh, great.
And if it's not buildable, yes, you can go before variance, but aren't there variances there to put in place to protect the lot and not to be putting,
Well, so we can't address the fact that he had the tractor in the water and all that stuff.
well, it's in the
That's-
picture.
Right, but that's not what this board does. We're
No,
we're
well,
here for
you
the...
asked me to submit some proof as to why I'm, in the last
well,
application.
I understand what you did. My thing is this isn't the forum to judge. If he had tractors in the water and stuff like that, that would be probably DEP or some other
That's not,
organization.
my point is not that it's wrecking the shore, the water, it's, he was pushing it all back.
So you're saying that he would
He
be... for his-
readjusted the lot.
So what you're trying to say is it's
The
actually
100-foot
where
setback
where the 100-foot setback would be
It's
further
not
back.
there.
Okay, all right.
It's no longer, it's not a valid lot. Not the one he purchased anyhow. That lot was offered to me and other people as the abutters. And my husband and I at the time, my husband's now deceased, but my husband and I at the time said, is it buildable? No. We don't need another, sorry to say this for the town, but I don't need another lot just to pay taxes. I've already purchased 3. So I don't know. I'm just amazed that that land got pushed back and we're not addressing it. Isn't that
So
the reason?
When do you believe it was pushed back then?
Well, purchasing, look at my notes, my pictures. I tell you it in my notes too. I mean, the pictures
You
are
have a copy of
dated.
those somewhere,
This
'cause-
is a different appeal.
Yeah.
This
That was
is,
a
this
previous
is,
appeal.
this is a previous appeal.
Right.
That's the one that has been stayed, the appeal that she's referring to.
Correct.
In the documents.
It's already-
This is an entirely different.
Correct. Why we're here tonight is to approve the variance for a smaller home, correct? A smaller,
Well,
set.
The-
No, we're still here
Buildable?
we're still here to see the setback. if it's, he has offered a smaller home, yes, but we're here to decide
Then
whether
how-
or not to grant him a setback.
Then how are you, if we have a 100-foot setback in place, that ruling is there, how are we allowing this to be addressed?
That's what we're here to figure out.
I think where the confusion is coming from, ma'am, is that we're here to determine whether or not they have received an undue hardship by purchasing this property and the setback preventing them to put a single-family dwelling in.
Probably at the time, it might have been, but they
That's-
altered the shoreline.
That's what we're here to determine. We don't have, we do have some DAP proof of DEP documentation of their site visit at that time, but that's a totally separate matter that we'll take up with
Okay.
the Baxters.
That's your.
Moving
That's not our,
forward.
that's not our
No.
jurisdiction.
That doesn't
That's
have,
nor is
that doesn't have
what's-
anything to do with the appeal or why we're
Okay.
here
Yeah,
today.
we can't address
You
that
need to
tonight.
address
That's-
that.
So as an abutter, why am I here?
You're here to give your opinion on whether you think we should grant the variance.
Based
As-
on,
As it stands right now, should we allow them to build at 81 feet? As you said, the corridor, you got an email or a letter when you went, and you had people come and check. They have the same letter from the Saco River corridor allowing them to build at 80 and a half feet.
so are you telling me just by decreasing that home 10 feet, there's a possibility that could fall into an approval?
That's what we're here to decide.
That's what I'm asking though. How
But
do?
that's what we're here to decide. We
Okay.
haven't decided.
So
yet.
what would cause me, I don't know. I'm not a lawyer and I don't really know what else, I mean, that's my concern, is the fact that the shoreline got,
The road.
Okay,
and my husband is gonna talk.
okay,
next,
sure.
if
Let's see
that's
what he has.
okay.
I'll let you collect your thoughts and he can come on
I
up.
appreciate it.
Sure.
My name is George Grebin. I'm against the house going up because the part of the land that he owns and the road, that part gets flooded. So if the house goes in, the stuff's getting pushed back towards the road. I'm not gonna be able, none of us are gonna be able to get in or out.
Okay.
In the winter months, it's frozen. In the spring, it's all water.
Is that maintained by the association?
Yes, it is.
Okay, all right.
And before the snow comes, they'll redo the road with dirt.
Okay.
By the time spring comes around, it's back in a hole and you have water. And sometimes, the water's pretty deep, and if you stall out, you're stuck.
Right, that makes sense.
The house isn't there yet. Once the house gets there, it's gonna be even worse. And
Well, again, that's gonna be something that would be addressed through the Association for Road Maintenance and
Right.
it would be, you
But-
know, through the town would have to agree on drainage and the way it would work.
But then now we get into a situation where, where's the drainage gonna go?
Right, sure. And that's, again, not something that we're gonna address here as far as road
And the
drainage.
water on the ground, there's a lot of water under the ground
Yep,
on the side we abut this lot he's talking about.
right,
There is water under the ground.
Yep.
And once you start digging, it's gonna change the whole situation.
and that's gonna be something that's, you know, gonna
I
be
understand
up to their
you- I
builder and
understand
stuff.
you
If this is
have to-
approved, then his
but-
builder's gonna have to deal with the water.
Right.
Yep,
But the water's, I'm worried about the water's ruining the road.
yeah, that makes sense. I get that.
Because if something happens, fire equipment can't come in,
Right,
you know? Thank you.
thank you.
Guess my question is, why are we here then, if you're saying it's not, we're not addressing that issue? What issue are?
We're here right now, ma'am, to address their reapplication or appeal in reference to their wanting to build within 81 feet of the shoreline. That's essentially what, more or less, I mean, that's summarizing very briefly, but we're not here to say where the shoreline starts and ends. We don't have, you know, we kind of depend on other people to provide us that documentation. I'm assuming that at some point, code enforcement will send us that.
I just still
Or show us
lost, I'm not sure what this tonight's meeting is about. It's about a variance
Yep.
to allow the building or the structure
Correct.
that is 10 feet smaller than the last variance request, correct?
Correct.
So, as an abutter, what would you need from us more than what we've already submitted on? I mean, I wanna be able to,
We still have your letter, I mean, and we heard your testimony today, that's what you're doing, you know, what I mean, you're explaining your issues that you have with them building the house, that's what we're here for, so you're now on the record as saying that you have issues with it, right? And you've written us a letter last time which said you have issues with it, and we'll take that into consideration
I mean-
during our deliberation.
yeah, my home is on the point.
Mhm.
I don't know if any of you are familiar with that area. So my home is on the point, and when those boats from the cove, because that's what we've always referred to it as,
Mhm.
come flying, all that stuff, my dock has not been in for 2 years.
That's everywhere.
It just gets bounced all the time.
Yeah, the erosion's definitely something that,
That erosion
needs to be
is
addressed.
terrible.
Yep.
Yeah, I'm just,
Yep.
okay,
No, I'm not disagreeing with you.
No, I just don't know what
Yeah,
there's
just
something I'm
listening to your
missing.
points.
There's something I'm missing here? Thank you very much.
Yeah, you're welcome. Anybody else? Yes.
Talk, please. Talk your issues.
So at that point, we can close the public portion. Did you guys want to
We want to allow rebuttal, and then.
Rebuttal, and then-
Once you're done, I just have a couple, just instructions,
Sure,
basically.
yep, go right ahead, sir.
Can you hear me if I just
Sorry,
say your?
Joe. We can, you see okay on that, Mike? Yeah. Okay, yeah, you're good.
Just briefly, I understand the concerns about activity on the shoreline, but what you have as part of the application is an engineered plan showing the shoreline and the distance that the proposed house would be from the shoreline. Mr. Baxter, maybe you can comment, but whatever happened on the shoreline didn't affect, is that true? The shoreline hasn't
Yep.
been altered in any
No,
way
the shoreline's
since
not been
this
altered
plan.
at all. Steve Everett did this plan after the incident, what they're talking about, and so it has not been touched.
Yeah. And with regard, the reason why we're back here is that, the board, the first time around, I think maybe the Baxters weren't expecting that they needed to submit as much evidence as they did. So what the board found, it's our burden to demonstrate that, it's our burden to meet the standards of the ordinance. And it wasn't that the board said you couldn't meet it, is that the board thought there just wasn't enough evidence in the record. So that, we believe we've done that this time around with the evidence of the restrictive covenants and what that entails, and distinguishing the other cases, and also with a smaller house it's not just 10 feet shorter. The shorter building allowed us to sort of rotate it, take it out of the front setback altogether, so.
Right, it definitely moved a little bit, because it was in the 25-foot
Yeah.
setback before.
Yeah.
Yeah.
So,
So just
That's
to be
all.
clear, this is, well, I'm not gonna ask. Yes, sir?
but it will also affect the wildlife situation, because there is wildlife that goes through his property that kind of beds there at night, birds, deer, stuff like that.
Yep.
Yeah.
And it crosses all over that
Yeah,
section.
and that's true of any open lot that ends up getting built on, so
Yeah.
I don't find that unique to this property, but I get your point.
And some of the trees that were taken down is kind of opening up the whole situation.
Sure.
But there are other permits that they'll need to get if they move forward with
And that's-
construction.
and that's why
They
I
address
under-
those.
I understand
will
that.
be- Yeah, I know.
There's gonna be a lot, there's gonna be a lot of other things, hoops to go through
Yeah.
after this one. Okay. Is there anybody else, public comments? We're gonna close that now. If you don't hear anything else, I think we're good. we'll go to you.
So just a couple of points for the board. I'm Ben McCall. You all know me, but just for the record, I'm the town attorney from Jensen Baird, and also in Portland, right across the street from Joe's office. Very convenient, although, we all drove the same distance to get here, but.
Through the same traffic.
I mean, just to clarify for the record, this is not an administrative appeal, so the town doesn't have, I'm here in capacity as advising the board, mostly on procedure and the law. So the town doesn't have a position on whether or not the variance should be granted. This is a situation that happens quite often, especially in, with older subdivisions, is like we experienced before. A plan that was created in the 70s or before will generally have lots that aren't up to shoreline zoning standards, which are mandated by the state. So, Scott, I think you already have done this, but just for everybody's benefit, the board's job tonight is somewhat limited, and you have gone through practically an identical application back in February. There have been issues raised, and I think it's perfectly a valid forum to raise issues about what could happen if the lot is developed. But those are all outside the scope of what this board is deciding tonight. As a practical matter, this is a multi-step process for developing a lot like this. Mike Gilpatrick is here with me, and he can answer any questions if I guess there's really no question he needs to answer at this point. He's obligated by the ordinance to deny a building permit in this situation if the application can't meet the minimum 100-foot setback between the nearest point of the building and the normal high water mark of Lake Arrowhead. The ordinance requires him to make that finding. And so when that happens, an applicant has two options. They could appeal that decision, but more likely than not, they're going to come to this board for a variance. And so like you did before, you are looking at 4 criteria, 3 of which the last time around you found in favor of the applicant and 1 in which you didn't. So if a variance is granted, that would permit the building generally in the, it would permit a building to be built with a setback to the water of now 81.5 feet, plus or minus. But that, as Attorney Savitsky just mentioned, would still have to go through a building permit process. There potentially could be other permits that are needed from state entities. And so if this board grants a variance tonight, that has nothing to do with other standards that would apply to the construction of that structure. And there are robust protections in place for trees, for wildlife, for other things in those areas that would be reviewed as well. I agree with Attorney Savitsky on the case law. There is one case, and this is really just to make sure that the board has all of the information in front of you. The Hall case that Joe mentioned before is definitely relevant, but there's 2 contrasting cases about this type of variance situation. The first is the Toomey case, which you've heard a million times before. Those facts are exactly as they were put, a situation where an individual owned 2 lots within a subdivision. One was on the water, one was across the street or shortly around there. A variance was denied in that situation, and the board's decision was upheld, and the court found that it was a reasonable return on that property to simply have a lot open for recreational purposes because they already had a house in that subdivision. There was also, I don't believe, any restrictive covenant on the property like this one has. The contrasting case is one called Summerwind Cottage versus the town of Scarborough. I'm not sure whether a variance was denied or granted, but essentially the board had made a finding similarly to Toomey that there was a reasonable return on a shorefront property without the ability to build a house because of those recreational purposes. The law court found differently there, though, because in that situation that property owner did not own another lot in the subdivision and so didn't have those residential opportunities available. Neither of those cases really look at the restrictive covenant issue that is perhaps unique to this case, but those are just summaries for the board's benefit about where you are. So Assuming, and of course, you are not bound by your previous decision, you do not set precedent as a board, and so it's entirely possible that you may want to look at the other three criteria differently than you did before. But assuming that you don't, and I frankly, from a advising you perspective, don't see anything different in the record that would lead you to believe that, your real goal is to determine whether there's a reasonable return possible. That's a tricky term. It's a term that has taken up a lot of case law over the years. Typically, it's understood a reasonable return is not a maximum return. So it does not guarantee a property owner the ability to do with their lot what they would like under every circumstance. But I do think that the presence of the restrictive covenant, which was not in the record last time, but now certainly is, I think that does play into the board's analysis, and the board should take that into consideration about the universe of possible uses, and whether you feel as a board that the uses that are permitted by law, not necessarily what they're getting away with now, but what these restrictive covenants would allow them to do and not allow them to do, whether that universe of uses that remains, if you do not grant a variance, would still permit a reasonable return on that investment. So that is not assuming that they do not need to prove that the lot is worthless to you, but you need to go through and reason one way or the other to determine whether there is that reasonable return. I think in terms of procedure, we've been through this song and dance before. Thing to keep in mind, I know that you have a sort of a checklist in front of you as part of your record. That's perfectly fine for tonight. I do suggest that you put together a more complete set of factual findings. As part of this, just keep in mind, although this won't be a problem on my end, state law does require you to adopt those findings within 7 days of a vote. And so if you do vote tonight to either grant or deny the variance, you just need to be prepared to come here in the next week in order to consider findings. Won't be very difficult on my end because, like last time, 95% of them are written already. So, so that's fine. I'm happy to answer any other questions on legal procedure or the law about that, but otherwise, you're at the point where you as a board can go through and deliberate as you will.
So that ends public comment, which we already did. So I'll open up for discussion. You guys want to do one at a time, or do you want to just kind of leave one for the last and go 2, 3, and 4? And
Yeah,
get
that's my thought. 2, 3, 4.
I like where your head's at. That's what I was thinking. All right, so just to kind of make this a little bit easier this time, since we've already done this, we'll do that. So question number 2, the need for a variance is due to the unique circumstances of the property and not to the general condition of the neighborhood. Does the applicant's answer satisfy this question? I just want to make sure, I always get these backwards, so I'll make sure I get this. I would say, it's motion to agree. You want to take a motion?
I'll motion to agree.
I'll second.
You taking care of that? All right, so any discussion you guys want to have on that before we officially vote? No? All right, so all in favor of the motion? Opposed, obviously not. Motion passes. All right, so the granting of a variance will, question number 3, the granting of a variance will not alter the essential character of the locality. Does the applicant's answer satisfy this question?
I'll move to agree.
Okay.
I'll second that.
All right, all in favor? All right. Question 4, the hardship is not the fault or action taken by the applicant or prior owner. Does the applicant's answer satisfy this question?
I'll motion to agree.
I'll second that one, just to make it different.
Okay.
All right, all in favor? All right, that one passes as well. So that brings us back to the question that we are really here for. Land in question cannot yield a reasonable return unless a variance is granted. So let's chat about this.
This is hard.
Can you give us a little bit more on the reasonable return definition? Like, I know we've done this before, but just for the benefit of everybody, just so we know, it's, fresh in our brain.
So, again, a reasonable return, I can read right from where I said before, in your previous findings, it sort of lays out the law pretty well. So, under the law, the failure to yield a reasonable return means the practical loss of all beneficial use of the land. And what that means is, it's not the entire universe of beneficial uses, it's truly the uses of that property that are allowed by local ordinance and restrictive covenants. And so, what you've heard from the applicant, just to summarize, hopefully without analyzing too much, is that they want to build a single-family home. You're free to disagree with this or not, but they've provided a copy of their deed, which includes restrictive covenants from the Lake Arrowhead Association, which restricts the use of the property to single-family uses. It also expressly says that they can't put RVs or tents unless it's a kid's tent that is accessory to, it's interesting.
After the residence is built.
Interesting. So, so that contrasts necessarily with how you were looking at this last time, because I know a lot of time was spent on the possibility that they could in fact use the property in those ways. The law court has also said that they are not required to provide economic proof that no reasonable return is possible, and so they're not required to get an appraisal that says if you can't build a house here, what the value will be. It's a little more flexible of a test. But it is their burden, as Attorney Vitsky said, that there is no other productive non-residential use of the property in the circumstance because of what they're asking to be. So the word productive, does a lot of work there, and unfortunately that hasn't been very well defined by the law court. I think what I would suggest to the board keep in mind, a couple of things. This goes more towards a different element of the variance that you've already decided in the applicant's favor, but it is not the case that you can hold it against the applicant necessarily that they bought a lot. Even at the time that they bought it, they knew that they would need a variance in order to put a house there. That's not a self-created hardship, that's what that typically goes to, but what you're really looking at is this was a lot that was bought in a residential neighborhood with the expectation that even though it was a non-conforming lot of record and could be built on, that they knew that they needed a variance for that. And so there hasn't been any economic, we paid X number of thousands of dollars for this lot in the record, but they don't necessarily need to provide that for you. What you're really looking at, I think, you need to focus in on what the expectations are of a person who buys a lot in the circumstance. What other uses could they potentially put this to, and would that be a reasonable return? Would that be something where the value of using the property for that purpose would be considered effectively reasonable in light of how much was paid for it and the expectations of when it was purchased? And so, would it be reasonable if to purchase a lot in a residential subdivision with that configuration and close to the property, if you knew in light of the restrictive covenants on there that you could not build a home? Because in effect, without a variance, it is definitely the case that they cannot construct a single-family home there. And so that is what a productive use is generally meant to be in the context of this. You have all the facts in front of you. It's up to you as a board to put those facts to the law, but there's definitely more information in the record as to that point than there was before. I don't have the same concern from a procedural standpoint that I did last time, and that was reflected in your findings. Does that answer your question?
Yeah, no, thank you. I think,
Okay.
Judy, did you have any?
Well, I'm really having a hard time with this because I feel you can put a dock there and you could have a boat. And people pay big bucks for docks.
Well, that's what I was, I agree with you, I
Other
don't disagree
bodies
with
of
that.
water.
Yeah, I
You can
mean,
go there and
But it's
swim,
only-
I believe, can't you?
Is that-
Only a few
Nobody
months out
stops
of the
you
year.
from swimming.
right.
No.
You could go there and have a picnic,
Yeah, sure.
yeah.
I mean, there's no,
Bring your lunch
nothing's
and-
clear, but, yeah.
You know, but on the other hand, I find it very difficult to think of having a picnic without any bathroom facilities. Being an old lady and
It's a great,
having young
it's a
children.
great point.
I find this,
Can't put an outhouse up, right?
you know, no
no,
running,
no,
no
no.
running water,
Not
and
an LEC,
so
no
I'm
portable
having a
toilet.
hard time.
No, it's a good,
Well, you're not gonna have picnics in the wintertime.
Well, no, but nobody's
And
gonna
it's
use
only-
it in the winter.
You can go
Right, so
snowmobiling.
that,
You could
that
go ice
makes it
fishing.
almost worthless in my eyes.
yeah, because the house, you can use all
all
your.
year round. I mean,
You can use it, you could go ice fishing. I mean,
Yeah.
what else would you do in the
it's
winter?
like
Steak.
probably, everything comes up to a few days a
You can
year.
skate, you can, snow,
You do a lot.
cross-country ski.
I can do all those things, and I don't own a shorefront property.
Yeah, well, you don't have to go on the lake to do it.
Well,
I think even Lake Arrowhead is a
I
public
think we
access, don't they?
approve it.
I think I'm having a harder time this time with the, still with the setback.
So-
Personally, because I feel like if we gave 10 feet on the other side, it would have gotten the house, majority of the house would have been out of that 100-foot. Right now, the entire house, almost the entire house is still within the 100 feet, even though we do have a letter saying that they approved it from
I have another question. You mentioned before something about the parking needing a variance also, and does that enter into this? I mean,
No.
you're not gonna make them come back and,
I'm only looking at the 81 feet,
well,
right shoreline right now,
right.
and the hardship variance.
There is a driveway described on here, proposed driveway, 100-year flood. It would, part of it would be,
That's actually incorrect. Speaking with Mike, the proposed driveway or parking
Appears to be.
would be over the septic field. And he says that with a certain type of foam, I can't remember what you called it, Mike.
H20 concrete chambers.
yeah.
They can park on
You
them.
can park on, yeah.
Right,
drive
which
on.
would eliminate, we'd be past the 100-foot mark, and we wouldn't need the driveway on the other side.
So the driveway now would be over the septic, where the picture of the septic is?
Correct, yeah.
Okay. Yeah, I mean, ultimately, I know we're looking at the return, but we're also looking at, you know, a pretty decent size, you know, it's a 20-foot variance when,
Excuse me, did you say the driveway would be over the septic?
yeah, that's what they
And
said.
Mike's saying what type of septic it is.
Saco River
Yeah.
approved it, right?
Right.
They said, aren't they pretty strict?
Yeah.
That's what I'm saying, like, I don't know, I mean, I was surprised to see the letter. So, just for my own knowledge, it says permit 15-573, that kind of implies that it was done in 2015, but it says it was approved in March of '23. Does anybody know, did you apply in 2000?
March of '23.
Right, but it just,
Their
no,
numbering is fluky.
okay, just
Yeah.
weird, it just seemed like the permit was actually like, they should have 15 numbered, I'm like, okay, so it took them 8 years to approve this? Like, okay.
And then when we redid the size of the house,
Yep.
we went back to Saco, and they reapproved it
Okay,
because we didn't go any closer to the shoreline,
okay.
okay?
Because this says 80 and a half and you're at 81, you said 81 and a half, did you mean 81? Or-
So the original letter was, from Saco River Corridor Commission would have allowed them to build effectively closer because
Right.
it would be an 80 and a half foot setback from the water. I think the new design would allow them to be built slightly further away from the water. So in effect, the amount of the setback that they would need, the deduction in the 100-foot setback would be less. Slightly, but still less.
The Saco River doesn't have a problem with it. I don't have a problem with it.
Right.
I didn't get anything from Saco River on this last thing.
Their original approval?
The letter, what I did?
Yep.
I only got the
Did we get a new
original
one
way
since this
back.
March of '23 or no?
Yeah, that's all
Or
I
is-
ever got.
That's
You probably have to call Saco
We have
River.
one dated April 2023, is there another one?
There's the email in the original from May 29, 2024.
That's your original.
It's in your, somewhere in
They were
amongst.
The new packet?
Yep, says I reached out to Haley at SRCC yesterday, forwarded her the new plot plan. She gave it to the director who has approved the revised plan. No need to submit a new application with them. Please see email below for your file.
Yeah, I don't have that
Which
email.
is-
I don't see that email, so it's okay.
It's a single page.
I believe you.
There, actually, it's 3 pages in length. It's got my name at the very top of it from Mr. Baxter.
Alright, so I guess the discussion still goes back to whether is he able to get a reasonable return currently without this variance?
I don't think so. It's not what I would want to use that piece of property for.
Right.
Just to go there when I can, maybe.
Right.
No, I'd want to put a house on it too.
Did you, anybody else?
Yeah, but that's not what we're looking at. We have to keep this very
I don't think
general.
it's
as
worth
far
running right
as-
now as is. I think it is.
What reasonable return means. It doesn't necessarily mean you have to have a house. It means you.
But Arrowhead says you can't do pretty much anything with it.
Right.
You can walk to the water.
So the other thing is, you know, you talk about return, and I know we don't have to adjust, we don't have to talk about how much he paid for it, but we also don't know, you know, if he only paid $6 grand for the property, is he getting a reasonable return by putting a boat down there? You know what I mean? Like versus if he paid $600,000 for this property, is he getting a rate of return? You know, I have a hard time not knowing the expectation from that side too.
You can certainly ask the applicant to provide that
You
information.
can still can?
Absolutely.
Okay.
If
You
you're
might,
gonna,
I'm sure we could look it up in town records if we needed to, but.
the only thing I'd say is that if you're gonna reopen the public hearing, which I think you need to do in order to allow that information to come in, just provide opportunities for anybody else in the public to rebut that or anything like that. But that's certainly appropriate if you need to. The applicant is here, so feel free to ask whatever questions you feel you need
Yeah,
to
change
get
your
out.
opinion or anything? Okay, all right, would that help you?
No,
Would
I
you
mean,
bother?
I don't think so.
Okay.
Because I don't,
Do you
yeah.
do you need to hear that?
No, I don't need to hear that.
Okay.
No.
All right. It sounds like we're not gonna be a unanimous crew here, so just wanna make sure that we do this the way that you guys want. So, does anybody wanna make a motion in reference to question 1, as far as the land in question, not yield a reasonable return unless the variance is granted?
I make a motion, we agree.
Anybody second? Judy? That not being seconded, is there any other motions?
If the affirmative motion isn't going to be agreed to, then I'm gonna need a negative motion
Yeah.
on that. Can't just. Does that make sense?
Yeah, but it wasn't seconded, so it just hangs, and then if.
Well,
if
that
it's-
motion
Didn't
can't
carry.
be brought to, right, so, you know, you do need to have a motion one way or the other on each of the 4 criteria.
Right.
So that motion does not succeed, so you're right back to where you were before,
Correct.
with the table being open.
I wonder if it would make a difference to the board, you know, we're trying to reduce the impact of the house to the greatest extent we can. And we thought that eliminating the front setback altogether would be one way to do that. But another way to do that is to move, I suppose we would have to talk with the engineers, but it might be possible to move it further from the shore and back into the front setback. So we'd need a variance from 2 setback requirements, but one would be from the road.
Right.
Maybe, you know, further away from the more sensitive resource.
Right.
Do all the other houses on that street meet the setbacks?
No.
Are they closer to the road?
Closer to the road or closer to the water?
Closer to the road?
I'm not sure about the,
No.
well, 25 feet, I'm not sure. What the distance is to the house across the street from me.
Mm,
It might be 25 feet, could be 40, I don't remember.
okay. At least 25, you think?
But it's got, they got a variance.
Yeah, like she said, she had
Sure.
three, you know, most of the people over there have a couple lots, so that's, you know, and I'll just say my piece, and the way my brain's working right now is, that it seems like this is kind of, I'm not gonna speak for him, because I don't think it was an afterthought, but I think he was told by the Realtor, you need a variance, you know, it is maybe buildable, but it's not conforming. You know, he testified to that. I'm having a hard time with, you buy a piece of property with all of these things in place, the variance can be given or cannot be given. You know, that's up to us to decide. I don't think, in my personal opinion, he's made it, so I'll actually make the motion to say that it does not satisfy this first question. Okay.
Who seconded it?
Yep. So, take a vote, all in favor? Against? Motion carries 3-1. So the motion to grant or deny. So we need a motion to grant or deny the
No,
application.
I'll move that we deny the application.
I'll second that. All in favor? Opposed? 3-1, motion passes. Yep. Either way, I think it is. So, in reference to the motion tonight that did not pass, so tonight it was denied, so if you're unhappy with that decision, we can request a reconsideration by the board within 10 days of the date of this decision, and or 45 days of the date of the decision pursuant to 30 MRSA's 2691, 4353, and Maine Rules of Civil Procedure 80D. And can I get a motion to adjourn?
Second.
All in favor? And this motion is adjourned, the meeting is adjourned.